introduction of IPAB, was there any challenges that you or the other officers faced because of it?
No, when I was there, only copyright board, and we found that copyright board was created as a ad hoc body. In 2012 amendment, we made it a permanent body. But before entire thing started working with appointment of a chairman was to be a sitting judge or is equivalent to be appointed as a member of the as a judge of the Supreme Court and all that didn't work out. And then finally in the tribunal reforms one phase, government thought out why there should be so many tribunals. This idea came after the national IPR policy came, which merged Copyright Office with the main Controller General Office as a part of Controller General Office. Okay. Then IPAB should be taking care of this also. Why there should be a separate tribunal? That was a great idea to disband Copyright Board and merge it with the IPAB. But before IPAB took up this, many things, the tribunal reforms too came. They said, these tribunals are necessary when already there is a commercial bench in each of the 25 high courts as per the Commercial Court Act 2015. Why again, creating infrastructure, resources, which finally the matter comes up, and that is not final, it's end up in High Court again.
Yes.
So, no need. But I don't think that any problem has occurred now. That's what the Delhi High Court did. Any, the administrative problems or understanding problems, they to help them in that. And IP is a big field, and we take patent only. The patent, various innovations are there. Maybe in the pharma, medicine, technology, the biotechnology and microbiology. Judges may not be equipped to know all these things. That's why the IP cells has been constituted, where the people with some knowledge sitting there, when such particular matter comes for the decision, they try to see and examine whether what the patent office has done correct, and accepting, granting a patent or rejecting a patent. These guys will help the judge. Right. That's a great decision by Delhi High Court. And I salute the judges in Delhi High Court. They are always one step ahead of other 24 high courts. They have been doing it. And that's what the Madras High Court has done. And now there is a need. The IP burdened High Court, like Kolkata, the Karnataka High Court, Bangalore, Mumbai High Court especially, and also some extent the Kerala High Court. These 4 high courts also have to set up IP cell to assist the commercial benches there. Okay. That's what the Delhi High Court has done that. Hopefully their Chief Justices will take notice of this issue and start setting up the IP cells in their high courts also to help the commercial bench, where IP cases are filed and examined and decided.
Right. Okay. Sir, I think you have been involved in framing the IPR laws in Myanmar and Bhutan, right? So how do you think are they different from ours, and do we need to get some good ones from them, or is ours better than them? How would you differentiate?
Thanks a lot for this question. So as a chief negotiator for India, whether it is a broadcasting treaty or submitting a proposal to revive the transfer of rights Article 12 in the Beijing Treaty, or the Marrakesh Treaty for access to published works for the visually impaired and print disabled. When we are doing this, WIPO Secretariat noticed my capability, and they approached me that can you help these countries to improve their copyright laws. So they normally go and conduct a workshop there, conference, a couple of days, and all stakeholders come, and expert like me are invited to give talks Not only that, they made us to interact with their policy making bodies, whether IP office, other people who drop the laws and do, amendments, to gain some experience from people like me.
Right.
So that's what happened, thanks to the WIPO Secretariat considering me as an expert to do this. So normally I found that their laws were not up to the rank, either minimum standards of the Berne Convention not there, the compulsory license mechanism introduced for the reproduction and translation, which India played a key role in 1967 Stockholm revision of the Berne Convention, which finally got finalized as the Berne Appendix in 1971 Paris Act, which India implemented, and they have not done in their laws. And then many have not either signed Berne Convention,
Okay.
and those who have signed Berne Convention automatically members of the TRIPS agreement, as per the Article 9, para 1, and somehow not signed the WIPO Internet treaties, not harmonized the provisions of WIPO Internet treaties. You know how WIPO Internet treaties came, the WIPO Copyright Treaty and WIPO Performance Phonograms Treaty in 1996, because Internet was creating lot of problem for protection of rights of authors, composers, and pop industries, film industry, music industry, and including software industry. So the internet in digital environment, their right need to be protected. So what these WIPO Internet treaties did, they extended the minimum standards provided in the Berne Convention, Article 1 to Article 21, including the Berne Appendix, the compulsory license mechanism, to the digital environment and online networks.
Okay.
That is the what that. So India in 2012 amendments introduced all the minimum standards in compliance of these WIPO Internet treaties. And also we went ahead. First time India suggested a model how to address this problem of transfer of rights, and we exported our language there, like the concepts like right to receive royalties, and signing the agreement, agreement to be in a written agreement with a signature, these kind of things. In the Article 12, you see the language, and there was also a problem about the issue raised by the EU delegation. They wanted a rebuttable presumption, and that request was already diluting the weakening the diluted clause, because the clause introduced was may clause, not the shall clause.
Okay.
And then I said you can't further damage that. Then at last we introduced that as per the domestic policy laws. So that's of the purpose. Like this, we tried our best to contribute there and also protect Indian stakeholders and their contribution and their creativity, and also the contribution of these industry to the economy. So that was the thing we did there.
Okay.
And these things we taught them in our interaction. And thanks to the Myanmar Parliamentary Standing Committee, they wanted me to explain their own law which is in the parliament.
Acha.
So that was the next step which
Yes.
I experienced. Normally when we go to our parliamentary standing committees, some questions are raised. Seniors is, get embarrassed, juniors replying. They say we'll give it in writing.
Acha.
Then I go back to office and then write and get it approved and send it to them. Here no one got
of
that
that
issue.
sort happened.
They simply invited me on behalf of WIPO, and WIPO took me there. And that was a great experience to
Of
their
course.
ministers and entire parliament members, explaining all the nitty-gritties of copyright law and the basics of Berne Convention and Rome Convention, WIPO Internet treaties, Marrakesh Treaty, and then how they are drafted and what changes need to be done in the draft. This is what.
Okay.
This what I did in Vietnam and Nepal, Maldives.
That's a big contribution, sir. Yeah. Okay. So as of now, what do you feel is the biggest challenge in the IPR regime that our nation faces, if at all?
Yeah, biggest regime is the online piracy.
Yes.
That is the big thing. and that need to be addressed. But again, thanks to our judiciary, whether it is Delhi High Court or Calcutta, Mumbai, and including the Madras High Court, they have started a new thing about 10 years back, that blocking the websites, pirated websites. And this model has become a best model across the world. And come to know recently that there is nothing is allowed in Japan, this kind of thing.
Yeah.
And I know this need to be replicated in other countries. What our judiciaries have agreed and put the stamp on that. And they give John Doe orders. Not only the pirated sites which are making available illegally to people, either stream or download or upload, and these are blocked. And anything new comes up. Normally the pirated website, the moment it is blocked, they come out with a different website with a different HTML this
Right.
addresses and all that. And John Doe orders are helping the film industry to protect. And another important thing is the circumvention of legal protection we are given as per the WIPO Internet Treaties, the digital rights management, technological protection measures. Now they are freely, entire film industry using the digital mechanism.
Yes.
Remember when I used to watch film as a kid, auto accident ho gaya or reel pahuncha nahi. They used to give us second interval till that reel comes and then film starts. Now that's no problem. It is digitally made available, and the watermarking and then secret key code is input. So that is helping to identify where exactly the piracy happening. And recently you must have read in newspapers, one of the film was revived from the regulatory body, censor board, and that was embossed on that film. So that was the source of that. But now the new technology they can use, blockchain technology, which is immutable,
Okay.
unchangeable. So their timestamping will be there. So the both industries, whether it is the film industries and the publishing industry, recently that's what suggested in Jaipur Literary Festival, one of the authors asked, he is not paid properly the number of copies sold in the market, he doesn't know because there is no transparency in the publishing industry. I told them, why don't you start the blockchain technology, use it. I can have internet facility and the author can log in and see how many copies printed, how many copies have been sold.
Okay. That's
And
a very good
what is his, whether is getting 10% royalties as agreed or 15% been put in his account or not. He can get an SMS. If he's registered the PAN card and Aadhaar card and bank account number, that's what we do. SMS will go to him, this amount has been, this is your 15%, these things they need to do. Use the digital technology intelligently, whether it is a blockchain or the digital rights management. It's a win-win situation. You can protect your right and distribute the earnings by film or music industry and other industries, publishing. And recently a beautiful thing happened in the presence of Honorable Sri Piyush Goyal ji. He, under his umbrella, the Indian Singers' Rights Society and Music Industry came together, signed an agreement which reminded you of 1993 agreement signed by Naushad ji of authors, composer with the music industry. Now the singers signed an agreement with them so that they can together collect the royalties and share the royalties for the performers' rights. This is a great development, disruptive development happened recently. These kind of things should go on. Of course, there is another problem is coming, the bigger problem that is already come, the artificial intelligence and generative.
You have just won the PhD, awarded the PhD in text data and artificial intelligence. So how did how did you choose this subject? What led you to choose this subject? It's such a niche
Yeah.
area.
And thanks to Mata Saraswati, she's the goddess of intellectual property rights. And she gave me the idea that do something which is going to happen more. So I
Futuristic.
already, because my IP and copyright started with the technology. IP law and technology is my most interesting happening. Then it was knocking the road. I remember when we were negotiating the Marrakesh Treaty, during the lunch break, my co-negotiator from the US Copyright Office came and asked, Raghavendra, what are you doing in the field of text data mining? It's a big thing happening. Then I just looked at him. We missed the bus. Because 2012 amendment already done, rules were all done. After that, Marrakesh Treaty happening. And then what to do? Then I thought something has to be done here. Yeah, we'll be doing something, I said. And then I thought, why don't, when this artificial intelligence algorithm coming and doing a lot of problem, why don't I take this as a research? So my topic is intellectual property, text data mining, and policy suggestions. Here, one chapter discusses about the AI inventorship.
Okay.
You must have read in newspaper how Stephen Thaller's Davos AI, even though it invented food processing technology, rejected by the US, UK, EU, IP offices. Of course, Australian office did a mistake initially granting a patent, and later they realized when the matter went to the 5-judge bench, they rejected it. All the basis for this, the entire intellectual property, the central idea of the intellectual property is to protect the intellectual creations, inventorship, innovations, and authorship and creatorship of humans, not of machines. So non-human will not get, the human will get, because in coming to copyright, it is the personality. His personality is getting extended through his creativity. Otherwise you don't know what kind of person is Premchand, what is thought process, or Rabindranath Tagore, or you
Yes.
take any famous author, his creativity is an extension of his personality. That is recognized. Machines don't have personality. Don't give a right to them. It is the non-human. Don't put spirit into them. People say now it is a low AI, and you have to give a prompt, is a written prompt or a voice prompt. Without prompt, tomorrow the high AI is coming with the deep learning and neural networks, and it itself thinks and writes. But still, and look at what kind of things it's writing. Already available in the digital database,
Not
whether
able
on
to
the
create
internet
anything
or in the
itself.
computer.
Yes.
So let us say that on the table in front of you, there is a physical book is lying. It is not been digitized or soft copy. Any of copies PDF or EPUB versions have been published by them. Not even specially formatted copies for the blind. How come your chat GPT or generative AI can read that and reproduce to you? Impossible. Then comes, I put a lot of tests to that, chat GPT and AI. And it can't read, it can read only 50% material available. It all depends on how you do the prompting to extract the information. That it's not everybody's cup of tea. And then if it is leaving out very important information, which despite that material available in the internet and databases, it is not giving it to you. How you can recognize it's an author, equivalent to human? That is the big thing. And registration, how you can register right for that. Other day I met my friend Shirapal Mehta, a Register of Copyrights and Director of US Copyright Office. And they are simply rejected because it is the prompt, whether written or voice prompt given, it's not natural person, you can't give it. And unfortunately, our copyright office did a mistake. there's a young lawyer called Ankit Saini. He filed an application for a generative AI called Raghav AI. They have given not my name, Raghav, some other inventor Raghav name they have given, and that created an artwork based on the Van Gogh's Starry Night painting. Is expressionist painter, my favorite, one of the favorites, and then took a photo of the sunset. So this AI, generative AI, did the learning, created the patterns, created the data sets, and tokenization, whatever the text data mining happens, and it generated a new work which they call is Suryast.
Oh wow.
It's a beautiful photo, and they went and filed for the copyright. Then Copyright Office of India, they said, okay, we should recognize the innovation, so we give you joint authorship. Then I got shocked. The definition of joint authorship in section 2Z, it says, two or more persons collaboratively creating a work is a joint authorship. Okay? Ankit Saini is a person. Raghav AI is not a person, is a non-human. How can a non-human you recognize as a person give joint authorship? They later learnt this mistake and withdrew. But how can you withdraw? Law says any rectification of register of copyright. A petition has to be suo moved by register of copyright. The earlier days copyright board, after that IPAB, now since office is located in Delhi, suo motu application has to be filed in commercial bench Delhi, and with a notice to the person interested, the party, whether it is Ankit Saini or the creator of AI, why they are withdrawing the copyright granted to them, and it will be heard. There will be adversarial hearing. Court will listen to both of them. Finally, give a registration that rectification is correct or not. So this mistake that. So unfortunate that people are not learning. AI is learning, and we are also learning. Ours is a physical learning. AI is digital learning. But question comes, these are the things at the time starting. So thanks to my American friend giving me idea, and then finally I did my PhD, and I'm enjoying it, and it is very dynamic, and 6 months already passed. I got my PhD award in January. Convocation happened last week, but still I find that if I start writing now, I write the thesis differently, because it's very disruptive environment and technology. New things are coming. When I submitted PhD, there was no ChatGPT.
Okay.
There is no stability AI's version of image creating generative AI called stability, the stable diffusion, and also the Mid Journey. These are the beautiful AI systems which can sing a song like Lata Mangeshkar, who passed away, same style and voice, or Talat Mahmood, or Kishore Kumar, or Mohammad Rafi, or existing singers like my friend Sonu Nigam, or Shreya Ghoshal, or any other singer you take. But is this a original singing? No. It is a generative work they are creating without consent, without compensation, royalties. They are not supposed to release these songs, mimic the voice, mimic the style in the market, and make money. Similarly, you can't release a book in the market, literary work, without taking a compensation, paying compensation and taking consent. And another problem, students. Many students are getting their projects written, article written using the ChatGPT. It is doing high-level copyright infringement. Okay, you may argue that education exception, research exception is there. I need not go and take permission project. Every book it has created, every work it has created data set and learning patterns and tokenization. Finally did visualization and given me a copy of the product. 1,000-word article or 5,000-word project report. Okay, agreed. Where is, the exceptions come from the legal access. It has not access from the all legally available works in which copyright is there. Okay, a copyright exception is there for education and research. You don't take permission. But what about the works? And you don't even take permission from the public domain works, out of copyright works available in the digitally in the databases on the internet. Third one is internet is full of infringed material, pirated material. People unauthorizedly copy and post it, upload it, and ChatGPT, generative AI collecting that data also.
Yes.
So entire concept of exception introduced in Article 9.1 of the Berne Convention, that exceptions are given for the legally access to copies. It's been repeated in the TRIPS agreement, repeated in WCT, WPPT. The entire discussion, 4-year negotiation and leading to the 9-day diplomatic conference in Marrakesh, Morocco, centered on lawfully accessed copies, the exceptions for the access to published works for the visually impaired and print disabled.
Right.
How can you get allow all these things happen with the generative AI platforms like ChatGPT 4 or Bard or whichever thing is coming, the Edge and all that? It
Yeah.
is totally infringement of copyright if you publish a book for commercial purposes. Leave it for the education research. But coming to education research, you are supposed to give citation,
Yes.
referencing whichever citation model adopted by your university or law school
Definitely.
or any other. No, I put a question, please give me citation after asking it to create 100 words paper. After buffering for 5 minutes, it comes out with one source and started reading from where, what it has taken, no one knows. I asked again question, it start answering all nonsense and not even single citation reference is given. It is plagiarism then.
Yes, plagiarism.
In passing off somebody else's work as yours and submitting your project report, an article without a citation.
Yes.
So, and when ChatGPT is doing so many nasty things, how can you recognize as a human autonomously writing and creating works and give copyright to it? Forget about inventorship and granting patent to it, because it is not a human, it's not to be given. But a learning itself is not, learning by, I'm talking about all this machine, is not infringement of copyright. And WCT is clearly, when any conversion of physical copy to digital copy is a reproduction, but there is an agreed statement to the Article 1 reproduction right that any incidental storage in the computer medium, electronic medium, is also a reproduction. But in Article 10, limitation exception says it is for the member states. They devise new exception to these kind of things. So India did it. Section 52, subsection 1B, in the 2012 amendment, we said any transient and any ephemeral kind of incidental kind of copying happens in the storage, computer storage, which ChatGPT is also doing, is not infringement of copyright. It need not do user who gives a prompt or the maker to go take permission, then only you start reading and learning. We also buy books or read books in internet. We don't take permission for reading and learning.
Yes.
But once you write a book, you have to respect the copyright, the
Definitely.
creator of the copyright. You give citation, you have to give referencing, and then if you take maximum quotations again, you need to take permission. You can't exceed the quotation levels.
Numbers,
also.
yes.
No. So this is it. This is what I explained to everyone who comes to me. It's a very interesting discussion.
It can go
happening.
on and on.